Ready, start. The present case before us is not the one based on circumstantial evidence but is based on ocular evidence. Time and again, this court has held that ocular evidence is the best evidence unless there are reasons to doubt it. To put it simply, in assessing the value of the evidence of the eyewitnesses, two principal considerations are whether, in the circumstances of the case, it is possible to believe their presence at the scene of occurrence, or in such situations as would make it possible for them to witness the facts deposed to by them, and secondly, whether there is anything inherently improbable or unreliable in their evidence. In respect of both these considerations, the circumstances either elicited from those witnesses themselves or established by other evidence tending to improbabilize their presence or to discredit the veracity of their statements will have a bearing upon the value which a court would attach to their evidence. Although in cases where the plea of the accused is a mere denial, yet the evidence of the prosecution witnesses has to be examined on its own merits, where the accused raised a definite plea or puts forward a positive case which is inconsistent with that of the prosecution. The nature of such plea or case and the probabilities in respect of it will also have to be taken into account while assessing the value of the prosecution evidence. There is nothing palpable or glaring in the evidence of the two eyewitnesses on the basis of which we can take the view that they are not true or reliable eyewitnesses. Few contradictions in the form of omissions here or there is not sufficient to discard the entire evidence of the eyewitnesses. It is only in rare and exceptional cases where there is some manifest illegality or grave and serious miscarriage of justice on account of misreading or ignoring material evidence that this court would interfere with such finding of fact. It is settled that the testimony of an injured eyewitness is accorded a special status in law. As being a stamped witness, his presence cannot be doubted. The testimony of an injured eyewitness has its own relevancy as he has sustained injuries at the time and place of occurrence, and this lends support to his testimony that he was present during the occurrence. Thus, the testimony of the injured eyewitness should be generally given due importance unless there are glaring contradictions. The fact that the witness sustained injuries at the time and place of occurrence lends support to his testimony that he was present during the occurrence. In case injured witness is subjected to lengthy cross-examination and nothing can be elicited to discord his testimony, it should be relied upon. Injury to the witness is an inbuilt guarantee of his presence at the scene of the crime, and because the witness will not want to let his actual assailant go unpunished merely to falsely implicate a third party for the commission of the offense.